In Nevada, we had the Nevada versus Redden case. This is the defendant, the clip of whom went incredibly viral when he supermaned over the bench and tackled the judge. This is the trial for everything that happened that day in court. He was there to be sentenced on a case he had previously pled guilty to. The court opened with opening statements that were interrupted because the court did have Zoom open, or Blue Jeans was a system they used, open, and somebody spammed the video and audio with inappropriate videos that caused, I think it was the clerk of court or the court reporter, to actually gasp as you heard the moaning over the audio system in court during the prosecutor's opening statement. The prosecutor, to her credit, recovered fairly well from the auditory interruption. They put on the record that none of that was seen by the jury, but it did interrupt the opening statements of the prosecution. And you could see the court staff being quite caught off guard. It seems that courts don't know how to mute all participants, so they can't unmute themselves and disrupt live court, which we have seen in other cases. And it doesn't surprise me that there were disruptions in a high-profile case. Courts have to know when cases are streamed. The internet will internet and sometimes intercede into the court case, even though they shouldn't. But after that, we saw the opening statements of both parties, the prosecution opening up with the defendant saying, "I tried to kill a judge today," and then showing the video of the defendant leaping onto the bench with full audio where you can hear the defendant saying, "Nah, fuck that bitch," and then flying at the judge. We saw the defense say 3.7 seconds from the time the bailiff handcuffs clicked to take the defendant into custody. There were 3.7 seconds before he was over the bench, and that was not enough time for him to form intent. They also talked about the defendant's mental health history, his mental health diagnosis, and that he did not form the intent to the attempted murder. He was charged with 7 counts. He had pled guilty to 6 of them and was only going to trial on the attempted murder of the judge. We then heard the judge testify, went through the injuries that day, that she thought she wasn't going to make it out of work that day. Watching the video back with the judge and her talking about the injury to her head, the force with which the defendant hit her out of her chair up against the wall behind her and knocked her out of her shoes, and then grabbed her hair as he held her on the ground. We then heard from the clerk that was next to her, her law clerk, who does her research and helps prepare her case calendars from the legal side. And he had very descriptive and active testimony. He was telling the jury exactly what happened, that he saw the defendant like winding up and wailing on the bailiff, that he saw the deputy coming around and get injured and his head had flapped open. It was descriptive testimony, but he was very much retelling and reliving what he had seen. But his mannerism with the jury was very much, "You're never going to believe what happened at work today. It was this, and then it was this, and then I saw this, and then I heard him say, fuck that, and then he's running at the bench." It was very engaging testimony, and I imagine that the jury was like, this is wild. And we saw the video again. The jury took a 15-minute break, and the court took a 15-minute break before cross-examination of the clerk of court. That break extended quite a while, and the defendant came back and pled open to the court to the sheet. What that means is that the defendant withdrew his prior guilty pleas for counts 2 through 7 and decided to plea to the court, no plea deal from the prosecution, to counts 1 through 7 as guilty but mentally ill. What that means is at sentencing, the defendant will have to prove by a preponderance of the evidence to the court that at the time of sentencing, he was mentally ill. His diagnosis of schizophrenia should count for that, which entitles him to mental health treatment and sometimes a different housing designation within the prison system so that he can receive that treatment that seemed to be beneficial to him based on his defense attorney's statements and opening statement. That is not a plea deal with the prosecution. That is the defendant coming to the judge saying, I'm guilty. If he does not prove the mentally ill component at the time of sentencing, which again, his diagnosis will generally cover, but if he does not prove that at sentencing, then he will just be sentenced to a prison term. He will get a prison term either way. The designation will just be different. So the defendant has pled. He will be sentenced in November. They will have a short hearing for him to prove that he was mentally ill at the time of his plea, which is the time he took the plea in court that we just watched. This defendant does have the same retained counsel as Keefe D, which was interesting to see. I did not know that he had hired the same defense attorney there in Nevada, but we will see the Keefe D trial in November. So we will see more of this defense attorney in November, and we will see this sentencing. The minimum potential sentence for this defendant, the bare minimum potential sentence, is 2 years. That's a mandatory minimum on one of the counts. The maximum is upwards of 50 years. I think some of those counts will consolidate. So he is looking at probably a substantial prison term based on the injuries to the judge, the injuries to the sheriff's deputy, and his behavior in court and his criminal history. So we will see that sentencing in November. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.